morning, everybody. Welcome to this seminar on disrepair. I'm joined today by Alexander Campbell and I'm Catherine Rowlands. I am waiting for a few more people to join. It's brilliant to have you all here. While I am waiting for those other people to join, I'm just going to tell you about our Housing Day, which is going to take place on the 9th of October this year. Hope to see you all there as well. This year we're taking over the Royal College of Surgeons, so we've got bigger premises than usual, so we can fit far more of you in. I'm not sure what they offer for lunch there. Hope it's not the product of surgery, but the exciting news for you today is that you are still in time to get the early bird discount. Tickets will normally be £145 plus VAT. If you book by the 12th of September, £20 off, £125 plus VAT, and you will get to see people like myself and Alex, but also people like Kelvin, Colgate, Andy Lane, Dean Underwood, all these people who you know and love and who will give you an update on what's happening in housing law this year, last year and next year. See, we've still got people joining, so we'll just give them a couple more minutes. We are going to get started. We've got a full session today. We've only got an hour to fit things in. We've got some exciting updates about the new legislation that's coming into force. I'm going to tell you about some recent case law of interest. Then we're going to have a chat about topics about tips and tactics dealing with housing disrepair, litigation. And then, as I say, we've got some questions at the end. So Alex is going to kick off talking about the new, I was going to say the new bill, I should say the new act, and he will start telling you all about that. Thanks, Alex.
Thanks, Catherine. Good morning. Nice to see everybody. Thanks for joining us. Appreciate that disrepair isn't always the most exciting of topics. So thank you for being here, because of course, however unexciting it can be, it is something that we all have to tackle very regularly. As Catherine mentioned, up until yesterday, the social housing regulation bill was precisely that, a bill. It gained royal assent yesterday. The final version, the fully published version of the Act is expected to be published sometime next week. So I'm going to caveat what I'm going to run through now by just saying that there may well be some changes in the final version of the Act when it's published next week. I did these slides while it was still in bill form, so please forgive me. I'm probably out of habit going to keep talking about it as a bill, but as of yesterday, it has now gained royal assent. So really the main function of the social housing regulation bill, which I'm going to do a little whistle-stop tour of now, is about trying to improve social housing standards. And that's primarily about giving the social housing regulator more teeth, more power to intervene when things go wrong. And that's come about in light of some very well-known prominent failures in the social housing sector over recent years. So one of the things the bill does is it changes it adds to the objectives of the social housing regulator. The regulator already has two fundamental objectives: an economic regulation objective, which is about trying to make sure that providers of social housing are financially viable, properly managed, and perform efficiently. And there's also a consumer regulation objective, which is about the regulator trying to ensure that the provision of social housing is well managed, of appropriate quality, that tenants have appropriate choice. And what the bill does, or the Act does, is that it adds some additional things into that objective. So the regulator now has a fundamental objective of making sure that social housing is safe, that it's energy efficient, and the regulator is to ensure that providers of social housing act in a transparent manner in relation to their tenants. One of the things that the new Act does is that it sets up or makes provision for an advisory panel. The purpose of that advisory panel is to provide information and advice to the social housing regulator, whether the regulator specifically requests that advice or not. And the panel is going to be advising the regulator on anything which could have a significant impact on registered providers or on the provision of social housing. So it's quite a broad remit. And under the legislation, there are certain interests, certain bodies which have to be represented on that panel. So the members of that panel have to include people who are there specifically to represent the interests of registered providers, secured creditors of registered providers, social housing tenants, local housing authorities, the GLA, the Homes and Communities Agency, and the Secretary of State. The legislation makes provision about the collection of information. So it says the regulator can require a person to provide documents or information which the regulator has reason to believe are in that person's possession. The regulator can require an explanation about any documents or information which have been provided. And the legislation makes it an offence, knowingly or recklessly, to provide the regulator with a document, information, or an explanation which is false or misleading. The legislation makes provision about the relationship between the ombudsman, the housing ombudsman, and the regulator. So it requires them to take such steps as they consider appropriate to cooperate with one another. It requires them to prepare and maintain a memorandum of understanding, which is a document setting out how they're going to cooperate with each other. And they have to publish that memorandum in the way they consider will best bring it to the attention of the public. And there's also a new requirement for them to consult with one another. Now, cooperation between the ombudsman and the regulator and the use of a memorandum of understanding is actually not something new. It's something that those two bodies already do. But what the legislation does is it really puts that on a mandatory statutory requirement. The Act makes provision about which enables the regulator to make registration of social housing providers conditional on their ability to show they can meet the required regulatory standards. There's then a whole lot of material in the Act about something called a health and safety lead, which the legislation introduces. So the idea of this is that providers will be required to designate a person to act as a health and safety lead. The health and safety lead's role will be to monitor the provider's compliance with health and safety requirements, to assess the risks of their failure to comply with any of those requirements, and to report any health and safety failures or any risks of health and safety failures to the provider's governing body, and advising the governing body what action needs to be taken. So what is a health and safety requirement? Well, under the bill, it's a statutory requirement relating to the health and safety of social housing tenants. The bill makes explicitly clear that that includes an obligation which comes about by way of an implied statutory covenant. And the bill gives a specific example of one of those covenants, which is Section 9A of the Landlord and Tenant Act 1985, which is the implied term that a property must be fit for human habitation. And it also includes a requirement which has been imposed by a notice given under other legislation or enforcement action. So, for example, enforcement action under the Housing Act 2004. Who is to be the health and safety lead? Well, it depends on whether you're a private registered provider or a local authority. And it also depends on the size of the organisation. If you're a private registered provider with 15 employees or more, then the health and safety lead has to be one of those employees. Otherwise, it can be an employee or an officer of the provider. And if you're a local housing authority, it depends on what your structure is. So whether you have an executive leader or a mayor. I won't go into all the details because they're quite precise, but just be aware that who the health and safety lead is depends on who you are and how big you are. And the bill makes clear that a provider can nominate someone to step into the role of health and safety lead in the event that the actual health and safety lead is unable to do the role because of illness or absence. Providers have certain duties towards the health and safety leads. They have to make sure that the health and safety lead has sufficient authority to be able to do their role effectively. They have to make sure the health and safety lead can devote sufficient time to that role, and also that the health and safety lead has the resources that they need to be able to do the role. A provider has to notify the social housing regulator of the name and contact details of that health and safety lead, and also has to publish that information more widely. Now, what's the effect of appointing that health and safety lead? Well, importantly, when it comes to legal liability for any health and safety problems, the buck still stops with you as the landlord. So in other words, the legal liability for any health and safety breaches doesn't pass to the health and safety lead. It still sits legally with the landlord. The Act amends the Housing and Regeneration Act 2008 to enable the regulator to set standards for registered providers in various matters. For reasons of time, I can't go too deeply into all of them, but they are competence and conduct of those individuals who are involved in the management of housing. So that means the regulator can make rules about what knowledge, skills, and experience people need to have who work in social housing, and what conduct is expected of those people when they're dealing with tenants. The regulator can make rules in relation to information and transparency. There's the power for the Secretary of State to direct the regulator to fix those sorts of standards if the regulator doesn't decide to do so themselves. There are various powers of the regulator to intervene. There used to be more general overarching powers. Under the new legislation, there are going to be much more targeted, focused powers for the regulator to intervene, and those are set out in Schedule 3 of the bill. And performance monitoring just means that the regulator can direct providers to collect, process, and publish information about how they're performing against the various standards. The legislation makes provision about property condition surveys, so that provides that the regulator can now enter premises at any reasonable time on giving 48 hours notice to carry out a survey of the condition of the property. They have to give notice to the provider and also to any occupiers, and they can give that notice by fixing the notice to a conspicuous part of the premises. There's also provision in the bill for the regulator to go to a magistrate's court and get a warrant. The warrant can be obtained if the regulator's tried the non-warrant procedure, which I've just mentioned, and that hasn't worked, or if the premises are unoccupied, or if the regulator has reasonable grounds to believe that they won't be allowed into the property if they do try to do it without a warrant. And the main difference with a warrant is that it authorises the regulator to use reasonable force if necessary. The bill makes provision for what are called inspection plans. So the regulator has to make a plan setting out what providers need to be subject to regular inspection, how often regular inspections need to take place, and in what circumstances providers are going to be subject to additional inspections above and beyond those regular ones. Having made that plan, the regulator has to take appropriate steps to implement it. They have to keep that plan, they have to publish that plan, and then they have to keep it under review and replace or revise it as necessary, and then of course publish any revised or replaced version. PIP, we're not talking about welfare benefits here, but performance improvement plan. So if the regulator is satisfied that a provider has failed to meet one of the necessary regulatory standards, or there's a risk that the provider is going to fail to meet the standard, or just the interests of social housing tenants requires protection in some way, the regulator can serve a performance improvement plan notice on a provider. That notice tells the provider what issues there are, what problems the regulator is concerned about, and requires the provider to prepare a performance improvement plan, setting out what action the provider is going to take to deal with those problems. The regulator can either reject or accept that plan. If they accept it, the provider's got to implement it in full. If they reject it, they have to give reasons for rejecting it, and the provider is then automatically deemed to have failed to comply with the notice. And if a provider fails to comply with a notice, that enables the regulator to then go on and take further enforcement action. If a performance improvement plan notice is served on a provider and they're not happy about that, they do have the right to appeal that notice to the High Court within 28 days. The bill makes provision for emergency remedial action. So the regulator can authorise people to enter premises to take specified action to remedy any failures by providers if certain conditions are met. Those conditions are that there has to have been a survey of the property. The regulator has to be satisfied that the provider has failed to maintain the premises in accordance with the necessary standards, and that that failure has caused imminent risk of serious harm to people's health and safety. and the provider has to have failed to comply with an enforcement notice requiring it to take action. The regulator can enter at any reasonable time without a warrant. They have to give 24 hours notice, or they can go to the magistrate's court and get a warrant enabling them to use reasonable force to enter. And it is an offence for a provider to obstruct the regulator in exercising its powers to enter, and likewise it's an offence by an occupier to obstruct the execution of a warrant which has been obtained. Where the regulator is proposing to take that sort of emergency remedial action, the provider can appeal that to the High Court as well within 28 days. So that's a bit of a whistle-stop tour of the new legislation. As I say, keep your eyes peeled next week when we should get the full published version of the final act as it got royal assent, and we will be talking much more about the about that new act at the Housing Day in the autumn, by which time we might have a bit more sort of flesh on the bones of that legislation. With that, I'm going to hand over to Kate, who's going to do a case law update, and then I'll be back with Kate later to talk tips and tactics.
Before I let you go though, Alex, we've just got one question on your presentation, which is about who should be the health and safety lead if the local authority housing stock has been transferred over to an ALMO. Who would you recommend as an H&S lead in those circumstances? Okay,
I'll tell you what, Kate, while you're doing your case law update, let me reply to that question, and then perhaps I'll share the answer when we come back to me.
Perfect. Okay. Move on to the next slide then, please. So case law updates. I've been talking about Section 11 of the Landlord and Tenant Act 1985, almost since 1985, and very rarely is it that I get to say, we've got some case law to talk about. This time I've got two to tell you about. I was hoping that by this time we would have some interesting case law to talk about the new fitness for human habitation provisions, but no such luck. Where is it all going? Nothing getting to the higher courts. Why not? Are you not fighting things? Or are you not getting claims that are worth fighting? Let me know, because I'd be really interested in taking something up to a higher court. Here's one, Khan and Mahmood, though, that went up to the Court of Appeal. And it's interesting for 2 points. The first one, of course, is that this is one where the Housing Law Practitioners Association thought it was so important that they intervened in it. At the bottom of that slide there, they've got the reference, and that link will take you to the case of Khan and Mahmood. Next slide, please, Alex. So this is a case where the Court of Appeal was considering specific questions about the quantum of damages for disrepair claims. It started out as a really bog standard disrepair claim. The landlord, Khan, the tenant, Mahmood. Well, that's where it gets a little bit more complicated, because Tariq Mahmood wasn't the tenant at the start. A friend of his was, and he moved in to help with the rent, and somebody else moved in to help him, and a new tenancy agreement was signed halfway through, and it all got very, very confusing as to who lived there, how long Mr. Mahmood had lived there, whether he was still living there, and whether he should carry on living there. So Ms. Khan brought possession proceedings. That's why she's the claimant, even though it's basically it's all about a disrepair claim. Next slide, please. Mr. Mahmood brought various allegations of disrepair. He said that the property was, generally speaking, damp. He said that there were unstable floors in the upstairs and filthy carpets. Anybody think that filthy carpets is an allegation of disrepair? No, it's not, but still, that one made its way into the court. There was a leaking roof. That's much more serious, of course, and that was aggravating the dampness in the property. Although the landlord did carry out some repairs, the repairs were, Mr. Mahmood said, inadequate to fix the leak, and the gas cooker became unsafe. And he said, generally speaking, the condition of the property deteriorated over time. And on the next slide, he said that he was unable to work. he got ill, and because he was ill because of the disrepair, that's why he got into arrears, he said. But certainly he got into substantial arrears, and litigation ensued. Next slide, please. So, although this is a recent case in the Court of Appeal, it goes way back to 2013. That's when the possession claim was lodged at court. The court in question was one of our favourite courts, Willesden. Could have been Central London, but no, it was Willesden. That's like Central London, only smaller. So a defence and counterclaim for disrepair was lodged in August 13, and it was listed on a day and then moved to another day. And so it was on the 2nd of September 2013 that it was listed, but the tenant didn't attend for understandable reasons. He got confused, and judgment was entered against him, possession counterclaim dismissed, and that was later set aside. So we were already getting into convoluted litigation. By February 2014, a reply and defence to counterclaim were submitted, and it was listed for final hearing in August 2014, as you'll see, just over a year after the claim first started. By this time, there were witness statements on both sides about, in particular, how long Mr. Mahmood had lived there and whether he was a tenant or not. When it was listed for the final hearing, it was, in fact, the landlord who didn't turn up this time. And so the district judge dismissed her claim and defence to counterclaim and gave judgment for Mr. Mahmood. Next slide, please, Alex. So on the counterclaim, the district judge's judgment for disrepair, was to give 50% reduction in rent. Now, he said that that was taking it as a global assessment, but he increased the amount of rent reduction to take account of the fact that the tenant had a claim for special damages. They didn't have any evidence in support of it, but the judge just said, well, I'll round the figure up, basically. So I'm sure the worst of special damages, you're probably entitled to something. I can't say how much, so I'll just give you a bit more on rent. And it was increased by 10% on the basis of the case of Simmons and Castle. I'll be talking about that case a lot more on future slides. The judgment also gave the deposit back and the penalty because the deposit hadn't been properly protected, and interest. Next slide, please. The landlord, not happy with that, applied to set aside the judgment. And by the time that application was dismissed, it was 2015. He also appealed against the judgment. Permission to appeal was granted in 2018 and was not heard until 2019. We're now 6 years on from the start of the claim. In the meantime, she takes separate possession proceedings and evicts Mr. Mahmood from the property. I'm not quite sure what happened on that, whether there was any set off argued or anything like that. But, you know, this is a long time for the things to come to court. And in that time, things get a bit unclear. And so it comes before one of my favourite judges, His Honour Judge Saunders, and he's on the next slide, please, Alex. He had before him 4 grounds of appeal. The first is that the district judge gave damages for too much of a period. First of all, he said the obligation to repair is owed to a tenant, not to a licensee. And so the defendant had no claim for the damages for the period when he was living there as a licensee of the actual tenant, and 2011 when he was actually granted a tenancy. He then argued that she, the landlord, argued that the district judge failed to set off rent arrears, which the defendant did admit he owed, and that was another ground of appeal. They should have been set off against the damages awarded. The order for the return of the deposit was erroneous because the deposit had already been repaid, and there was no proper basis, she argued, for the order to carry out works. She then raised what she said was a subsidiary point, that it was wrong as a matter of law to increase the damages by 10% to account for the principle in Simmons and Castle. So Judge Saunders dismissed all grounds of appeal, and as we will see, the Court of Appeal wasn't very was very kind to him, I think, later on. Now, he dismissed all grounds of appeal mainly on the basis that the claim had been struck out, and he didn't see all the documentation. He didn't see some of the witness statements and some of the admissions about how long the tenant had been a tenant. And when we get to the Simmons and Castle point, which is what the Court of Appeal was primarily concerned with, he said, although it doesn't strictly fall within the grounds of appeal, the appellant has raised an issue with regard to this judge's decision to increase the general damages that he's ordered in his final order by 10%, invoking Simmons and Castle. The appellant says this is a wrong approach and that a rent rebate approach should be adopted. I disagree. He said this is a case involving physical inconvenience and discomfort to the defendant, and it was a civil case. The district judge was correct to apply the Simmons and Castle uplift to the facts of this case. So when we went to the Court of Appeal, there were two grounds. One was about the period of the claim, period for which the tenant was a tenant, and the second, and by far the more important one for general purposes, is the Simmons and Castle issue. So what's Simmons and Castle all about? It goes back to 2013, and it goes back to the fact that in 2013, conditional fee agreements were brought in. Before that, we couldn't bring use conditional fee agreements to finance a claim for damages. But with effect from 1st of April 2013, the court said in Simmons and Castle, the proper level of general damages in all civil claims, pain and suffering, loss of immunity, physical inconvenience and discomfort, social discredit or mental distress will be 10% higher than previously. And then there was a little bit about section 44.6 of LASPO, which it really isn't of any interest now. So you will see that these are all about CFAs, which are used to bring personal injury claims primarily. Once again, I find housing law tends to be the poor relative when law reform is being considered. The courts are very good at dealing with road traffic accident, tripping and slipping, personal injury claims, generally speaking, and indeed catastrophic injury claims and things like that. They don't tend to think about housing cases when they change their rules and when they think about things like this. But the Jackson report talked about cost, generally speaking, and he said basically 10% increase would pay off for the fact that the success fee was not recoverable. So CFA agreements were brought in. You couldn't claim the success fee from the other side. So that meant that your damages that you actually got in your pocket was going to be less. So the 10% increase was supposed to make it more manageable for claimants so that they could carry on a business footing. So the solicitors who were doing CFAs on a regular basis were not out of pocket. In Simmons and Castle, they said, can you go back a slide? In Simmons and Castle, they said the increase may be a windfall for claimants who are not on CFAs. But the level of general damages, he said, is not high at the moment. So the abolition of recoverability would be an opportune moment for the raising of the level of damages, generally speaking. So this is general damages for pain, suffering, and loss of immunity, personal injury claims. Does that apply across the board into disrepair claims? Now the next slide, please. Now, should it apply in disrepair claims? The landlord said it shouldn't do. He said, the landlord said the Jackson report did not intend to uplift damages for disrepair because they're contractual. General damages for breach of repairing covenant are based on the compensatory principle. That is to say, they're supposed to put the tenant in the position that they would have been had it not been for the breach of contract, breach of the tenancy agreement, which says you will have a property that is in a good state of repair, it's in breach. What's the compensation for that? That will put you in the position that you would have been in had you had a property in a good state of repair. And they pointed out that because it's a percentage of the rent, that corrects for inflation and other matters. Personal injury claims are falling behind the rate of inflation, particularly recently, of course. That wasn't the case in 2013 so much. But because rents go up year on year, so will awards for disrepair go up year on year. And they pointed out on the specific facts of this case, the district judge had bumped up the damages to include special damages, and the uplift is supposed to be for general damages, not special damages, and so he was getting a windfall. He was getting the penny and the bun, as the court said in Simmons and Castle. Next slide, please. Now, because this is such an important point, our friends at Helper decided to intervene to argue that the uplift should apply to all disrepair claims. As far as I'm aware, Charla, Social Housing Law Association, put in written submissions, but I haven't seen any reference to them in the judgment. They said that Simmons and Castle were supposed to apply to all civil cases. So this is a civil case, no reason to make an exception to this one. The fact that the assessment of damages for loss of amenity starts with a calculation based on rent doesn't put these cases into a different type of case. It doesn't fall outside the Court of Appeal's reasoning in Simmons and Castle. The reference to a percentage of rent in the award of damages is a broad brush approach. It's not a precise calculation. And the fact that it's rent doesn't necessarily mean that inflation is already taken into account. And also, disrepair claims aren't just contractual. They're not just about the breach of the repairing covenant. There are claims for damages in nuisance or for personal injury under the Defective Premises Act, and they would clearly attract the 10% uplift. And on the next page, on the next slide, please, the other argument that they really argued strongly was that many of their claims are CFA funded, and so the real thinking behind Simmons and Castle applied. So another consequence of LASPO, they said, was to reduce the scope of legal aid for housing disrepair cases. The number of legal aid practitioners specialising in this area is falling, and representation by CFA is increasingly common and necessary for potential claimants. The success fee is a vital part of the sustainability for representation for tenants, particularly those in social housing or at the lower end of the private housing market, who are unable to afford legal fees out of their own resources. Removing the Simmons and Castle uplift, thereby reducing the level of general damages, would have an adverse impact on success fees and the availability of legal representation for such claimants. The tenants, of course, agreed. Next slide, please. And they said there's no merit in the argument that 10% uplift should be confined to cases where damages are assessed by reference to a tariff, like the judicial guidelines for the assessment of damages in personal injury cases, where you look at a tariff and you add your 10% on, and it's very easy to do it. I mean, the guidelines, the book these days does the working for you, dead easy. If you're a judge, you just run your finger down the page, pick the right tariff, Bob's your uncle. There's nothing in the approach to general damages for breach of a repairing covenant as propounded in the case law to support excluding such damages from the scope of the uplift. Next slide, please. And so the Court of Appeal did agree that the Simmons and Castle 10% uplift should apply to disrepair claims. They were particularly convinced, I think, by Helper's argument that CFAs are an essential part of making sure that social tenants should have an effective remedy. And I think in terms of, the bill that the act Alex had just been talking about and the cases that gave rise to that, there may have been some impetus behind that thinking there. They said that claims for damages for disrepair manifestly fell within the scope of Simmons and Castle. And they said even where the rental value is used as the basis for calculation, particular circumstances of the tenant may lead to either an increase or a reduction in the quantification. For that reason, the fact that taking a notional reduction in rent as the starting point may sometimes, though not invariably, incorporate an adjustment for inflation is no justification for excluding such damages from the scope of the uplift. Next slide, please. They looked at these well-known authorities on how you calculate the quantum for damages and basically affirmed them all. So the first one that they went back to is the case of McCoy and Co and Clark, and in that case, the court had said the object of awarding damages against a landlord for breach of his covenant to repair is not to punish the landlord, but so far as money can, to restore the tenant to the position he would have been had there been no breach. Sorry, I'm reading for Calabar and Stitcher rather than McCoy and Co. I'll carry on reading it though, and I'll come back to that. This object will not be achieved by applying one set of rules to all cases, regardless of the particular circumstances of the case. The facts of each case must be looked at carefully to see what damage the tenant has suffered and how he may fairly be compensated by a monetary award. So McCoy and Clark damages were assessed by reference to the proportion of the rent, but in Calabar and Stitcher was a global award. And the question that the court was looking at is what's fair? What is fair to compensate the tenant for the disrepair? Wallace Manchester, very well-known case from 1998. We're talking about the diminution in the value of the property to the tenant. And in that case, it was suggested that you award a proportion of the rent as a separate head of damage and do a global award as well. And the Court of Appeal in that case said that the diminution in rent is not a separate head of damage. And Sign and English Churches Housing Association emphasised that whilst you can take either approach and there is no tariff, and it was suggested that it should be £1,000 tariff per annum, happy days in 2004, if an award of damages for stress and inconvenience arising from breach of the landlord's implied covenant to repair is to exceed the level of the rent payable, clear reasons need to be given. So generally speaking, there are two approaches that you can take. You can take a global approach, looking at it as I think it should be about £1,000 kind of approach, or you can do it as a percentage of the rent. Either approach is valid, but if you're going above the award of rent, then you really need a good reason to do so. Because the idea is always it's compensatory, it's not to punish the landlord, generally speaking, it is to compensate the tenant and put them in the position they would have been had they not had this breach of the repairing covenant. So how does that work in practice? Next slide, please. So your two options. If you're doing a global assessment, start off with your global assessment of how much it should be. Personal injury claims are easy to do that. You've got the tariff. You haven't got any tariffs in disrepair cases. What you have got are previous cases. And of course, you're looking always at the previous cases, working them up for inflation and also adding 10% on top of that. But the rent payable is always still the touchstone by which the rightness of that award has to be assessed, unless there are special reasons, which are, the landlord has been an absolute bastard in the way that they have treated the tenant. The landlord has been really reprehensible. Hopefully none of my local authority clients would be anywhere near that kind of situation. If you do it on a percentage of rent basis, so you're saying you pay £100 a week for a property that is 100% in repair. If the property is 50% in repair, you only pay £50 a week, so you get £50 back in compensation. It's a really nice, easy way of calculating that. The thing is, of course, your assessment of 50% or whatever it is still finger in the air. How much should it be? You've got a 4-bedroom property, 2 of the bedrooms have got dampness, the kitchen is riddled with damp, and the toilet leaks. Is that 50%? Is it 40%? But you should still be saying it's 50%. And then you work out how much that is, and then you add 10% of the damages. So you don't say, well, normally I would have said 50% of the property is in disrepair, but because of Simmons & Simmons, I'm going to say 60%, it's 10% of what you would otherwise have awarded. And again, the cap of 100% of the rent will still apply. Even if you've got the 10% uplift, you should be still saying the cap is still the rent, unless there are special reasons to exceed that amount. So that's the, I just splash water up my face. That's the thinking. Castle and Simmons uplift applies even to disrepair cases. I found that hard to get my head around in relation to the percentage of the rent calculations. It didn't seem to me to be right in principle, but the Court of Appeal have said I am wrong about that. So, so just going to read the question there. So success fees from damages. If a tenant has significant rent arrears, the agreed level of damages for disrepair is less than the arrears, surely it's still lawful for a landlord to insist that all of those damages should be set up against the arrears on the rent account, even if this means that the tenant's advisor cannot directly deduct their success fee from the damages. Do you agree? Now, let me try and answer that. You've got two separate things that the parties to a contract owe each other. If I owe you £20 and you owe me £20, we just shake hands and go our separate ways. If I owe you £20 and you owe me £30, I'll say, just give me £10 and we go our separate ways. The same principle, it seems to me, should apply. So you can deduct everything until you get there. And yes, I do agree that if that means that the tenant's advisor cannot directly deduct their success fee from the damages, that's their loss. They should have thought about that at an earlier stage. That's my view. Don't know if anyone else has different ideas. Right, next slide then, please, Alex. The other ground of appeal in Carner Mahmood was for the period when the tenant was not actually the tenant, and lovely Judge Saunders had got confused because he hadn't had the documents. You know, it's been 6 years, things had got lost, and the Court of Appeal said he got that wrong, but we're very nice to him because he is a very nice judge. And so they said defendant only became tenant of the property in March 2011, and it was only at that point that he became entitled to the benefit of the term implied into the tenancy agreement, and therefore was only entitled to damages for breach from that date onwards. So the damages he got was 50% of the rent, because this 50% as the district judge had agreed, paid under the tenancy as from the date he became the tenant. And so he got too much. So the landlord's appeal succeeded to this point. Now, they then came back to court afterwards because they couldn't agree as to whether it should be March or May, because what the district judge had said was the landlord was only in breach from 2 months after being put on notice of the need to carry out repairs. Now, the landlord had been on notice really throughout. She'd been on notice certainly from 2007, before Mr. Mahmood became the tenant. So did she get the benefit of that grace period, the 2 months, which was a reasonable period of time to carry out repairs, which happened before he became tenant? Did she get a new period of grace at the time she became a tenant? I don't think it was fully argued, but actually the Court of Appeal did say, yes, she gets the grace period again, even though she was already on notice at the very start of the tenancy and should have carried out repairs before then for the previous tenant. She does get a grace period from the start of the new tenancy. So the moral of this story is always to look at a period of compensation that takes into consideration a period during which the grace period, the reasonable period of time for carrying out repairs. And because she'd won on one point, lost on the other point, she got some of her costs, but not all of it. Okay, moving on to the next slide, please. An interesting case from the first tier, the upper tribunal, Mr. Roger Casey, Deputy Chamber President, on appeal from the first tier tribunal. And this is a really good judgment for analysing the effect of Section 11 of the Landlord and Tenant Act. And in this case, the issue was a block of flats with a lift that kept breaking down. And the first tier tribunal held that it was a common facility, so the landlord was obliged to repair it. So that was Section 11, 1B, because 1B says, so 1A says, the reference in Section 11.1 includes any part of the building in which the lessor has an estate or interest, and installations which serve the dwelling house, which are in the common area. And Mr. Roger held that the first tier tribunal in this case had approached Section 11 the wrong way around. Do it differently. Start with what is within the repairing obligation. Section 11.1 requires you, as I'm sure everyone on this call knows, to repair structure and exterior of the property, installations for the supply of water, gas, electricity, space heating and heating water, etc., etc. And so if you look at a lift, it's not part of the structure and exterior, it's not part of the supply of water, gas, electricity, it's not part of the sanitary installations, etc. So it doesn't fall within section 11.1. So section 11.1a has to be compliant with that. So it doesn't mean everything in the building, it's limited to the same things as 11.1. So a lift isn't part of the section 11 repairing covenant, generally speaking. Section 11.1a doesn't extend it, because you have to look at section 11.1b. It says nothing in section 1a shall be construed as requiring the lessor to carry out any works or repairs unless that affects the lessor's enjoyment of the dwelling house, which they're entitled to use. And you have got to look at it in the context of coming through the gateway of section 11.1 first. So things like entry phones on communal doors, things like lifts, and other parts of it. Things that are not the structure and exterior, sanitary installations, etc., will not come within that part of the Act. Now, of course, it may come in section 11 in other ways, or it may now come in the fitness for human habitation provisions, but that's a really useful explanation as to how section 11 works. All right, Alex, I'm moving on to you now, and oh, I'm so sorry, I have one more slide. This is really interesting in light of what Alex is talking about in relation to the new Act and what the Housing Ombudsman might do. Housing Ombudsman is giving examples, here are all the links for you, of what's good practice and what's bad practice. So the London Borough of Newham praised for good practice, making good investigations. They've done the works, they've offered £50 compo. Live West had responded quickly to a ceiling collapse on Live West. They did take longer than 28 days, but that was a reasonable period of time, said the Ombudsman. On the other hand, poor old L&Q, who really do get a bad rep and don't really deserve it, in my view, did delay in dealing with damp and other repairs. Interesting point there, they did get the lockdown period when they couldn't carry out repairs, and the award was only 15% of rent. No mention of any uplift on that one. And the Live Housing Group one, damp and leaks going unremedied for 4 years. Top tip there, your repair logs were not sufficiently detailed. Make sure you've got records. And the landlord was ordered to have a review of other properties in the same block that might have been affected as well. So these kinds of awards give us an idea into what might be happening when this Act is put into force. Fairly low levels of compensation, fairly low, fairly generous decisions on what's a reasonable period of time. Okay, sorry, next slide, Alex, and it's over to you, I think, now.
Thanks, Catherine. So just to answer the question that was asked about the new Act, which was about who should be the health and safety lead in the case of a local authority that has an ALMO. So I wanted to go back to look at the legislation, and my view is that on a sort of plain reading of the legislation, it would be someone at the local authority. I should say, though, that the legislation is not sort of, although it was given royal assent yesterday, it's not all coming into force straight away. The government anticipates it coming into force sometime next year. So we should have a little bit of time to actually get to grips with it. And it may well be the case that we get some clearer guidance about some of those issues, which might be a little thorny. But that's my view on the way the legislation's worded. So in the sort of time we've got left, we just wanted to run through some sort of tips and tactics, just some practical advice and views from our experience of dealing with these cases at court. Just on this slide, I've just sort of set out what sort of claims we're talking about. So all the breaches of various express terms or implied terms. It's all about the records. One of the most frustrating thing, I think, for us as barristers is when we have to fight disrepair cases and there's a real lack of clarity in the records. The records often don't say what was actually done. It just sort of indicates that something was reported. There's then a reference to that issue being quote unquote completed, say a week later. And yet we then see in records that appear not long after that, that actually there are still problems. And it's very difficult to try and defend those cases when it's not clear what was actually done, were the works actually completed? And if so, what specific works were done? It's always better, if possible, to get really good evidence, take photographs of what's going on, ideally get the tenant to sign off on any works that have been done, confirming that they're done to a satisfactory standard. Common issues which come up are causation and recurrent problems. So what I mean by causation is sometimes tenants, if they have a leak coming in, if they have a leak in their bathroom and then it's fixed and then a year later there's another leak in the bathroom, there's sometimes an assumption that it's the same issue that's reoccurred. Actually, sometimes it's not. It might be completely unrelated. It might just happen to be in the same room or in the same area. And as for recurrent problems, one of the difficulties fighting these cases can sometimes be where the records show there was a leak in the bedroom, it was fixed a week later, and then throughout the next year, we have sort of another dozen or so reports of a leak in the bedroom and it was fixed a week later. On its face, that tends to suggest that actually the problem was never properly resolved. So it's important to sort of stand back and take a bigger picture look at the problem. Who can make records and how? Well, various different ways. Records might be kept by the person who's actually attending the property, but it might be someone in the legal department who makes a record somewhere or sends an email or something to record what's been done and any issues that have arisen. As I say, in this day and age with smartphones and so on, the more evidence in terms of videos and photographs we can get of disrepair, the easier it's going to make to defend it later on. Of course, sometimes there may well be delays in works being done, and there can be all sorts of reasons for that. It might be the scale of the works involved, maybe more investigations are needed, maybe the contractors don't have the right parts, or there may be difficulties getting access from the tenant. Whatever the issues are, keep a record of it. And more importantly, if it's a problem on the landlord side, keep the tenant informed as much as you can, so it doesn't look like it's just sort of disappeared off into the ether. When is the best time to get legal advice as a landlord? Well, I think the answer to that is probably yesterday, because usually by the time certainly we get asked for legal advice, it's often quite late into the process when it can actually be sort of quite difficult to sort of untie some of the problems that might have occurred. So get legal advice, whether that's from an internal legal department or externally from people like ourselves, but the sooner the better, because if there is a disrepair issue, the sooner that it's addressed and any appropriate offer in damages or compensation is made, the better protected you're going to be on costs, because you can avoid the litigation rolling on and on and on, and the costs mounting up and up and up. I wanted to spend a little bit of time just quickly talking about the pre-action protocol for housing disrepair cases. It was amended to make clear that it now applies to fitness for human habitation cases as well. And I say on this slide, it can often be seen as a nuisance, but actually used well, it can be quite a clever strategic tool that a landlord can use to their advantage. The landlord is a letter before, the tenant has to send a letter before action. The landlord is deemed to have received it 2 days after the date of the letter. And there's various things that the letter before action is supposed to contain, and I've set out the main ones on that slide. The landlord has 20 working days to provide a response to that pre-action letter. The letter should also include a schedule setting out specifics of what the issues in the property are, as well as a schedule setting out any special damages which are being claimed, any bedding, clothes, anything that's been damaged by the disrepair. But often it doesn't include those things. And this is why I say that the pre-action protocol can be a strategic tool, that actually if we really hold the tenant to their obligations, it can be quite helpful in defending these claims. As I say, the landlord has 20 working days to reply. That's a relatively substantial time. So my advice to landlords is always to make the best use of that time. It's absolutely fine to send a holding response immediately saying, we're looking into this, we'll get back to you. But quite often responses to letters before action are just a holding response and there's nothing else sent. It's really good to send a more substantive response. So use that 20 working days to look into the problems. What do the repair records show? Has the tenant actually reported any issues? Has the tenant provided access when it's been needed? And do you need counsel's advice? And if so, try and get it as early on as possible during that 20 days. You need to disclose documents or records that are requested, but you only need to disclose relevant records. So don't feel obliged to disclose absolutely everything if it's sort of clearly historic or it's clearly not relevant. And if you do need time to investigate, let the tenant or their lawyer know that you need a bit longer. These are things that our response should set out. Do we admit liability? If not, why not? Issues around notice, access, schedule of works. If we recognise there is a problem there, let's say early on what we're going to do and how quickly we intend to do it, particularly because that might might sort of stop the tenant from issuing proceedings. And if we think that something has gone wrong and some damage is owed, let's make a sensible offer of compensation to try and avoid the claim getting to court. The issue of experts should be raised in the letter before action. So this pre-action stage is a chance for us to get control of the expert issue. So normally there's a single joint expert. That's the approach that's encouraged. But if the tenant nominates a proposed expert and we as the landlord don't respond to that, if we don't object, then by default, that expert is going to be the expert. So this is a really good chance for us to try and get control of that issue, particularly bearing in mind how important expert evidence is when it comes to disrepair claims. And really think about the expert that the tenant has nominated, because sometimes they will nominate an expert who might not be an appropriate person. It might be a surveyor, when actually what you need in this sort of case is an environmental health officer or a heating engineer. I did a case a little while ago where the main issue was that some of the windows had broken. And the tenant's lawyers instructed a surveyor to attend, and the surveyor turned up at great expense and wrote a report saying, yep, the windows are definitely smashed, obviously completely unnecessary and just racked up costs needlessly. So think about what sort of expert, if any, is actually needed. The right mindset is to think of the pre-action stage as not just a mere formality. It is an opportunity to dispose of a good claim without it ever going to court. So if something has gone wrong, use this as an opportunity to remedy any issues, pay any compensation, and avoid it going to court. But equally, if it's clearly a bad claim, then send a good pre-action response, which points out what the problems are, which shows you're going to make a fight of it and that you're alive to what the weaknesses are. Because, for example, if there have been issues with getting access from the tenant, your pre-action response might be the first time the tenant's lawyers have had wind of that. So that might give them pause for thought. And on a very practical level, there are potential costs consequences if we don't engage at the pre-action stage. So that's why it's really important. Respond on time, send your response on time, and so comply with the pre-action protocol yourselves, because that enables you to insist on the tenant complying strictly with the protocol. It's very difficult when the matter gets to trial for us to sort of criticize and pick holes with a failure to comply by the tenant if we ourselves haven't complied with the protocol itself. And it's also an opportunity to make appropriate concessions. So if there are good bits to the claim and bad bits to the claim, be frank and upfront about the good bits, try and get rid of those, pay compensation, give a timetable for remedying those issues. And then if all you're left with is the bad bits of the claim, then that's going to be a much easier claim to fight if indeed the tenant and their lawyers decide to get to court. I've just put on this slide the numbers which dictate whether the claim will be on the small claims track or the fast track. If there are more than £1,000 worth of works being claimed under specific performance, it's going to be fast track. So actually at the pre-action stage, if you can get in and do the works then, so there's no specific performance claim left, you might be able to get it on the small claims track, which is really good because there's no costs orders as a matter of course on the small claims track. And for a lot of these claim farming companies that bring disrepair claims, it is all about the costs. So if it's on the small claims track, the claim will sometimes go away very quickly. Pick your battles. If sometimes there's a temptation to fight cases almost on principle, to say, actually, we've been getting loads and loads of these claims from this firm, and we really feel we need to, regardless of the merits, we feel we need to show that we're not going to keep paying compensation. If you're going to do that, make sure this is a suitable case for it. If it is actually a claim where there's a really good, there are some merit behind it, it's not a good one to try and make a point of principle. Likewise, if it's a litigant in person bringing a claim, not a great one for fighting it on principle. Much better to do that if it is being brought by a solicitor's firm that is bringing lots of claims against you. Think about making sensible offers. Making a good offer as early as possible is really important because it will stop the clock running on your potential costs liability. And as I say, for a lot of these, for some of the claim farming companies that bring lots of these claims, it's all about the cost. So a really well-made, sensible offer at an early stage can get rid of the claim. And if there's a hearing, if there's a court hearing coming up, whether it's a trial or a directions hearing, think about making, if appropriate, an open offer. So it's an open correspondence. So you can refer to it in court. The judge can be aware of it. In some cases, that's really helpful because the judge can then express a view about the wisdom of that offer. Will a tenant show up? The reason I raise this is because in my experience, sometimes, particularly with some of these claim farmer companies, they bring, I think sometimes they persuade tenants to bring claims by telling the tenant, actually, don't worry, this claim, very few of these claims ever get to court, we'll settle it, we'll get you some money, you won't ever have to go to court to give evidence. Sometimes once it becomes clear that the landlord's going to fight this to trial and the tenant is going to have to actually turn up and give evidence and really sort of stand by what they've said, sometimes at that stage, tenants just lose interest and fall away. Likewise, as a landlord, you might be able to make clear at the pre-action stage or in your pleadings that there are issues that the tenant might actually not want coming to light in court. So, for example, if there's evidence suggests the tenant's not been living there, perhaps they've been unlawfully subletting, that would be an appropriate thing for you to raise because it's relevant to the tenant's damages if they've not actually been there. So it's an opportunity to flag something up that might cause the tenant to reconsider whether they really want to fight this. And then just some common issues that come up. The Homes Fitness for Human Habitation Act, that's coming up more and more. The question of mitigation of loss by tenants. If the tenant says they've done things to mitigate their loss, insist on proof. Tell them to put their money where their mouth is. If they say they've been staying in a hotel for various periods, ask them for receipts, ask them for evidence. Likewise, if they say they've been staying with a friend, ask for details of the friend so they can prove it. Is there a personal injury element to the claim? If they're saying that the disrepair caused them some really serious physical harm, then you might be able to argue that the shorter limitation period for personal injury claims applies, which is 3 years, as opposed to the typical 6 years for a disrepair claim. And finally, think about the surveyor who the tenant is proposing to instruct. I've had a few cases recently where there was a conflict of interest because it turned out, without the tenant telling us, that the surveyor's firm and the solicitor's firm were actually owned by the same overarching company, which the tenant didn't tell us, and we managed to find that out ourselves as the litigation was going. Needless to say, as soon as we flagged that up, that claim disappeared rather quickly. And likewise, think about the quality of the report. If the tenants have gone ahead and just obtained their own report, think about the quality of it. Sometimes the quality can be really quite poor, referring to the wrong legislation that's not in force yet, legislation that's in force in England but not Wales, if it's a Welsh case. So there can be all sorts of reasons why the report is defective. And if it's really, really defective, that in itself can be a basis for applying to strike out the claim or to get summary judgment on it. That's a very quick sort of run through some of the key sort of practical considerations that I think we as barristers come across in disrepair claims. But we did just have a few questions submitted in advance of the webinar, which we're just going to run through quickly. So, Catherine, do you want to take the first one?
Yes, before I do, I'm just going to answer Simon's question about the upcoming Merthyr Tydfil Court of Appeal case listed on the 8th of November. It's an argument that complaint procedures must be fully explored and investigated before a pre-action protocol letter of claim is sent. Which way do I think it's going to go? I can see arguments on both sides, but I know that some local authorities are having lots of success in arguing this. I know Stoke, for example, I don't know if anyone's here from Stoke, have had some success on that, and also arguing that before you make an application for specific disclosure, you should make a subject access request. So the fact that that's succeeding may well point to that. I think I would say probably 60-40 in favour of it going in favour of the local authorities. But, you know, I'm hedging my bets on that one. It's an interesting one to watch. Certainly, we should encourage people to use complaints procedures and the LGO rather than getting into litigation. I've looked at the question. The first one that we have on the screen here is about temporary accommodation for homeless applicants. And of course, any local authority placing a person in temporary accommodation has to satisfy that they're suitable. So you will, of course, have ensured, where it's a private landlord, that the provisions of the Homelessness Suitability of Accommodation England Order 2012 are complied with. That includes ensuring that any accommodation that you put someone in all the relevant certificates, etc., and are in good repair, and that you've got a proper landlord. But basically, if you are the one on the tenancy agreement, you are the one that's responsible for making sure that the property is in good repair. And it is something that you can pass on then to your private landlord, depending on the terms of your agreement. But you shouldn't be putting people in property that's in disrepair, even for a day, even for a short period of time. Alex.
Thanks, Catherine. So the next question, which I'll deal with, is to outline the liability where a council flat is subject to leaks or including unexpected flood from the flat above in scenarios where the upstairs flat is or is not a council freehold property and where no notice has been given. Well, if the upstairs flat is a council property, then the situation is much more straightforward, because the landlord is going to have, council as the landlord is going to have a much easier time and more remedies at its disposal to get access to that property and to remedy any problems which are in there which are causing the flood. In relation to the scenario where the flat upstairs is, let's say it's completely privately owned, that is not itself going to mean that the council are entirely absolved of needing to do anything, because the council would still have potential legal remedies to in nuisance or so on, because that something going on in the upstairs flat is still affecting the council's property, which is the downstairs flat. So the council could still be expected to take legal action to try to get access to that upstairs property. Of course, if it's a really serious torrential leak, then you could have recourse to, say, the fire brigade or somebody like that to try and get really emergency access if you're worried that it's so bad the floor might cave in, for example. And on the question of notice, if the upstairs flat is a local authority property, then it's going to be more difficult for the council to say that it wasn't on notice, because it would be expected to be doing sort of inspections and having contact with its tenant anyway. But if it's a private privately owned property, then as long as the council's tenant downstairs is putting the council on notice of the flood, then the council is going to have to take action. Catherine.
Okay, the right expert. Tactical advantages of using an external surveyor as opposed to your in-house. This has been an issue ever since I was yay high. Lee and Leeds City Council, we had this way back when. So in-house surveyors are fine, but they are, generally speaking, less qualified than an external one, and not as good at just coming over in court as being a fluent and persuasive expert. Obviously, it's very rare that you get to hear them, but if they're answering all the right questions and they do a good report, they're as good, if not better, than somebody instructed as an external surveyor. Joe has raised on the question and answer session Gowing Law, who have got their survey report that comes along with the pre-action protocol letter. And I know that Gowing's surveyors are their own team surveyors, so they own a firm. So Gowing Law own a firm that runs the surveyors, so they're getting the money for the survey report as well. And I don't think that's an independent expert, and I'm trying to get some struck out on that basis. So you can always go to court to have them struck out, disallowed, and no, they're not supposed to get the survey report right at the start. As Alex was saying earlier, the pre-action protocol says if you can provide evidence like a photograph or something, a broken window is a broken window. You just need to provide a photograph of it. You don't need a surveyor, and you don't need Gowing's in-house time surveyor to go around at huge expense and get that sorted. Internal surveyors, should this report be CPR compliant? Yes, 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 and yes. The duty of the surveyor carrying out a report is to the court first and foremost. And if they don't say that, then they are going to be struck out. So make sure that you dot all the I's, cross all the T's. And if you have a problem with an expert, either side, you can make an application to court for the court to resolve any disputes that you have. Sorry, I'm getting tired now. My tongue is falling over itself. Katrina says Anthony Hodari are doing the same thing, Ultima Legal Services. So this seems to be a nasty little trend. Let's get something together. Let's get a higher court appeal to get this one explored by the Court of Appeal, or at least the High Court. Katrina, I see your cat is also providing expert reports, and I'm sure your cat is doing the best reports out there. Can my cat Cinders also apply for a job, please? Okay, we're just going to finish off with the last question very quickly. Alex, over to you.
Thanks, Catherine. So I'll just take the last question, which is a challenging claim from the start. So if a claim comes through that's just not accurate or not correct, so for example, the tenant who's trying to claim is not actually the occupier of the property, can the landlord simply refuse the claim? Well, the answer to that is that if a letter before action has been sent, then the landlord needs to respond to that. Now, if the claim is just nonsense, so for example, if actually the landlord knows that the person who's the subject of that letter actually just doesn't live in that property and never has done, it's going to be a very short letter. It can be 1 paragraph explaining that. If the claim's been issued and there's particulars of claim, then you're going to have to file a defence. But again, you might be able to keep the defence relatively short and punchy if that's the case. I wouldn't recommend, if by refuse the claim we just mean sort of do nothing at all and ignore it, I wouldn't ever recommend that. I think whether it's pre-action or been issued, you need to respond, but the length of your response can certainly be much shorter if actually the claim is clearly manifestly complete nonsense. So those are the questions that were submitted, and we've tried to sort of get through the ones asked in the Q&A. I know Kate and I, we've both got our emails on the slide. So I know, certainly speaking for myself, I'm very happy for people to email me after today if they have any burning questions.
Yes, indeed. Thank you all very much. We've still got some more questions coming in. We're over a quarter of an hour over time already. So thank you all for those really interesting questions. And it's been great to have those coming in and to share experiences with you all as well. I hope we will be able to meet as many of you as possible at our housing day, which I'll just remind you, 9th of October 2023, the lovely venue of Lincoln's Inn Fields, and the early bird discount runs until the 12th of September. We've got our emails there. Get booking and hope to see you then. Thank you very much for joining us today. Thank you, Alex, and we will see you all in October, hopefully. Bye-bye.
Bye-bye.